He didn't know he was already too late. He was 44 years old, partner at a private equity firm, the kind of man who had a personal assistant schedule his dentist appointments and a driver who knew not to make conversation before 9 in the morning. He wore the same brand of watch my father once pointed at in a magazine and said, "That's what success looks like." He had a laugh that filled a room and a handshake that made people feel chosen. He did not feel chosen the morning my attorney's process server walked into his firm's lobby and asked the receptionist to confirm his name. But I'm getting ahead of myself. My name is Claire. I was 31 when this started, a nurse practitioner working out of a family clinic in Austin, Texas. I had my own apartment, a used Subaru I was proud of, and a 5-year plan that involved a graduate certificate and maybe, eventually, a dog. I was not looking for a relationship. I was not looking for anything except a Friday evening where I didn't have to think about insurance codes. I met him at a colleague's birthday dinner, one of those long tables at an Italian place where you end up talking to whoever sits across from you. He sat across from me. His name was Richard. He asked questions and actually listened to the answers, which was disarming. He ordered wine for the table without making a production of it. He was funny in a way that didn't require an audience. We exchanged numbers. I told myself it was nothing. It was something for about 4 months. We didn't put a name on it. He traveled often. I worked long shifts. We saw each other when the calendar allowed, which was maybe once every 2 weeks, sometimes less. He never once mentioned the word future. I told myself that was fine because I hadn't mentioned it either. Then I found out I was pregnant. I sat with that information for 3 days before I told him. I needed to be sure of what I wanted before I said a word to anyone else. I'm built that way. I process quietly and then I speak. By the time I called him, I knew. I wanted to keep the baby. I wasn't asking for anything. I was informing him because he had the right to know. He went very still on the phone. I could hear his breathing. Then he said, "I need a few days." I said, "Of course." He took 5. When he finally came back to me, he asked to meet in person. We sat in the coffee shop near my clinic on a Tuesday morning. He was already there when I arrived, which was unusual. He was always slightly late, always slightly rushed. That morning, he was early and very composed, and I understood immediately that he had prepared for this conversation. He told me he was not in a position to be a father. He used that phrase exactly, not in a position, as though parenthood were a job posting he wasn't qualified for, rather than a consequence of choices already made. He said he had a complicated life. He said he cared about me. He said he would take care of it, financially, all of it, whatever I needed, but that he hoped I understood he couldn't be involved. I asked him what he meant by take care of it. He slid a folded piece of paper across the table. I looked at it without picking it up. It was a number, a large number with more zeros than I had ever seen attached to my name. I folded it back up and pushed it across to him. I said, "I'll be in touch." I drove to work. I saw 11 patients. I ate a granola bar over the sink in the break room at 2 in the afternoon. I did not cry until I was in my car in the parking garage at 7:15 that evening, and then I cried for about 4 minutes and then I stopped, because 4 minutes was all I was willing to give that situation. Then I called my sister. My sister is 2 years older than me and works in family law in Denver. I did not call her because she is a lawyer. I called her because she is the person I call. But she is a lawyer, and by the end of that conversation, she had already said 3 things that changed how I was thinking about everything. The first was, "You don't need his permission for anything." The second was, "Texas family code is not optional for him." The third was, "Do not sign anything, do not accept anything, do not respond to anything in writing until you talk to someone in Austin who does this for a living." I followed all 3 instructions. Her name was Margaret. She was referred to me by a colleague of my sister's, and she had been doing family law in Texas for 19 years. She had the kind of calm that comes not from peace, but from having seen everything. She shook my hand at our first meeting and said, "Tell me what happened." And I told her, and she listened without interrupting once, which in my experience is rarer than people think. When I finished, she said, "Do you want to pursue voluntary acknowledgement, or are we going to court?" I said, Whatever protects my child most, she said. Then we go to court. I was 7 weeks along at that first meeting. We moved quickly but methodically. Margaret explained everything in plain language: the paternity process, the timeline, the discovery phase, what Richard's attorneys would likely do, what we would do in response. She never once made me feel like I was an inconvenience or a charity case. I paid her a retainer that took most of my savings, and I did not regret a single dollar. Richard's response, when the papers were served, was not what I expected. I had expected anger. What I got was a phone call, not from Richard, but from a woman who introduced herself as his attorney and spoke in the measured tones of someone who had been briefed to be non-threatening. She said Richard wanted to resolve this privately. She said he understood my position. She said he had authorized her to make a formal offer, a structured settlement, a very significant sum, in exchange for a signed agreement that would release him from any future legal obligation regarding the child. The number she quoted was larger than the one on the paper he had slid across the coffee shop table. I thanked her for the call. I told her my attorney would be in contact. Then I called Margaret and told her what they'd offered. Margaret said, "Of course they did." She said it the way you say "of course" when something confirms exactly what you already knew. Then she said, "In high-income cases, child support isn't symbolic. In Texas, it's calculated on net income. There's a cap, but there are also provisions for extraordinary expenses: medical, educational, child care. What they're offering you now is a one-time payment designed to look large but cost them less over 18 years than what a court would require." I asked her what she thought the difference was. She told me. It was not a small difference. I said, "Then we keep going." Richard's attorneys were not pleased. The tone of the communications shifted. They became more formal, more pressured, with language around privacy and discretion that my sister, when I read her the emails, described as trying to scare you without technically threatening you. There were suggestions that this process would be difficult, that it would be public, that it would affect my professional reputation in ways I might not anticipate. I had been a nurse practitioner for 6 years. I had held the hands of people who were dying. I had delivered news that broke families and news that put them back together. I was not going to be frightened by a lawyer's email. I told Margaret about the communications. She said, "Good. Document everything." I documented everything. The paternity process in Texas moved on a schedule that Richard's attorneys could slow but not stop. There was a court-ordered test. Richard's attorney filed 3 separate motions in what Margaret described, with the faint professional disapproval of someone who has seen every delay tactic in existence as not their finest strategic hour. The judge denied all 3. I was 22 weeks pregnant when paternity was confirmed. I remember sitting in Margaret's office when she called with the result and feeling something I hadn't expected. Not triumph, not relief exactly, but a kind of settling. Like something that had been leaning finally found its footing. I pressed one hand flat against my stomach and I said, "Okay, what's next?" What was next was the support hearing. Richard showed up to court in a suit I recognized as expensive and with an expression I recognized as controlled. He had 2 attorneys flanking him. I had Margaret. He looked at me once when I walked in and then looked away. And I thought about the man at the Italian restaurant who had listened when I talked. And I understood that person, and this person, were not exactly the same. And that was the last time I spent any energy thinking about who he used to seem like. Margaret had prepared for 3 months. She knew his income structure, the salary, the bonuses, the equity distributions, the partnership draws. His attorneys had spent considerable effort making his compensation appear modest. Margaret spent 40 minutes methodically demonstrating that it was not. The judge listened. He asked precise questions. His clerk took careful notes. Richard's lead attorney argued that the guideline cap should apply and that any extraordinary expense provisions were speculative. Margaret said, "Your Honor, the child's father earns in the top 1% of income earners in this state. The cap exists to protect people of ordinary means. It was not designed to provide shelter to a man of significant means from his obligations to his own child." The judge looked at her over his glasses for a moment. Then he said, "Continue." I did not look at Richard during this. I looked at the table in front of me, or at Margaret, or occasionally at the middle distance. I was not there to watch him suffer. I was there to make sure my daughter had what she needed for the next 18 years, and the most useful thing I could do was stay calm and let Margaret work. The ruling came 6 weeks later. The monthly support figure was more than 4 times what Richard's attorneys had proposed in their initial offer. The court also established provisions for medical expenses, educational costs, and a college fund contribution reviewed annually. Margaret read me the document over the phone, and when she finished, she said, "This is a good order, Claire." I said, "Thank you for everything." She said, "You did the hard part." I thought about that later. I turned it over in my mind the way you turn over a sentence that doesn't quite mean only one thing. The hard part. I had done the hard part, which was not the court dates or the legal fees or the depositions or the waiting. The hard part had been the Tuesday morning at the coffee shop when I pushed that piece of paper back across the table, and in doing so chose a path that was longer and more uncertain, but did not require me to make myself smaller or my daughter invisible. My daughter was born in October, 7 pounds, 4 ounces. She has my mother's nose and an opinion about everything, which I suspect she gets from me. I named her Nora. She does not yet know the details of how she came into the world, but she will someday when she's old enough to understand that the story is not about her father. It's about what her mother chose when it mattered. Richard has a court-ordered visitation schedule. He uses it sporadically. His attorneys negotiated the terms. My attorneys agreed to the minimum that protects Nora's interests. I do not have feelings about his level of engagement that I spend time cultivating. My job is to be present for her, not to manage his relationship with her. The court document handles the practical parts. The rest is up to him, and that is not something I can control or want to. What I can tell you from the other side of this is a few things that I wish someone had told me. The first is that the legal system in this country is imperfect, but it does not care about money the way people with money believe it cares. A judge who has been on the family court bench for a decade has seen every version of this situation. The strategy of appearing financially modest and hoping the other party is too intimidated to push back is a strategy that works on intimidated people. I was not intimidated. I had Margaret. The second is that the decision to accept a settlement is irreversible. Once you sign, that is the number. That is the arrangement. There is no coming back later when you realize the childcare costs are higher than you expected or the medical expenses don't stop at birth. The one-time payment is designed to feel large in the present tense. The court order is designed to function over 18 years. Those are not the same instrument, and you should not evaluate them as though they are. The third is that privacy cuts both ways. He wanted privacy. He wanted a signed document and a closed door, and the ability to move forward without this following him. What he didn't account for is that I wanted privacy too. I had no interest in a public spectacle. I went to court not to humiliate him, but to establish a legal structure that couldn't be renegotiated informally, that couldn't be withdrawn when it became inconvenient, that had the weight of a judge's signature behind it. The very thing he wanted to avoid, the court, was the thing that gave me the protection he never would have provided voluntarily. People ask me sometimes whether I'm angry. The honest answer is that I don't have enough hours in the day to maintain anger at him. I have a daughter who is currently obsessed with frogs and wants me to read the same book to her every night, and has recently discovered that if she puts her arms up and says, "Carry me," in a very specific tone, I will carry her regardless of how tired I am. I have a career I find meaningful. I have a sister who answers the phone on the first ring. I have a life that is full in a way that has nothing to do with Richard and never did. What I have instead of anger is something harder to name. A kind of clarity, maybe. The understanding that the moment someone shows you they see your child as a problem to be solved financially, they have told you everything about who they are and what they will offer. You cannot negotiate a person into caring. You cannot take enough money to make the absence hurt less later. What you can do is build the strongest possible legal foundation for the life you are going to give your child anyway, with or without him. I went to court instead. Nora is asleep right now, 20 feet from where I'm sitting. The support payment processed this week, as it does every month, as it will continue to do for 17 more years. The college fund grows in the background. The legal order sits in a file folder in my filing cabinet, unremarkable in the way that important things become unremarkable once they are settled. He thought money was the whole conversation. It turned out it was only the beginning of one. There is a version of this story where I take the money. I have thought about that version. The number was large enough that I could have paid off my student loans, bought a house, built a cushion that would have made the early years of single motherhood softer in a material sense. I understand why someone might take it. I am not here to judge any woman who has made that calculation under pressure and exhaustion and the specific fear that comes with facing something this large alone. But I also know what that version costs. You sign once, and it is done. The number on the paper becomes the ceiling, and there is no court, no judge, no legal order standing behind you when the childcare bills come in or the medical expenses don't stop the way you expected. You trade long-term security for short-term relief, and you do it at the moment when you are least equipped to evaluate the difference clearly. What Richard did not understand, what people like Richard rarely understand, is that the confidence behind an offer like that is not actually about the money. It is about the assumption that you will not know what you are entitled to, or that you will be too tired or too scared to pursue it. The offer is a test disguised as generosity. It is a door that only opens one way. I walked through a different door. The outcome I received was not luck. It was the direct result of a set of decisions made one at a time, under pressure, when the easier choice was available at every turn. The decision not to respond to his attorney's first call without speaking to Margaret first. The decision not to accept the second offer, which was larger than the first, and framed in language designed to make refusal feel unreasonable. The decision to sit in that courtroom and let the legal process do the work it exists to do, without collapsing under the weight of what it costs me to get there. Accents produce outcomes. That is not a complicated idea, but it is one that becomes very clear when you are living inside a long consequence. Richard's choices, the ones he made across months and years before I ever knew him, and the ones he made in that coffee shop, produced a specific result. My choices produced a different one. Neither of us got to escape what we set in motion. What I want to pass forward to anyone sitting with a piece of paper and a number and a decision that feels impossible is this. Clarity is a skill you can build. It does not arrive on its own. You build it by asking hard questions and staying with the answers. By finding people whose judgment you trust and actually listening to them. By refusing to let urgency, someone else's urgency, designed to shorten your thinking, make the decision for you. Nora will grow up knowing that her mother did not take the shortcut. Not because shortcuts are always wrong, but because this particular shortcut would have required me to decide, before she was even born, that her future was worth exactly one number on a folded piece of paper. She is worth considerably more than that. I knew it then. The judge agreed.